Good morning, everyone. I hope you are doing good. Well, I shared some notes on the bankruptcy, and I hope that we are going through the same. I later on realized that you people have a separate unit called bankruptcy and insolvency accounts, which will a bit shrink our topic because then going to the insolvency accounts will be overlapping the other units. As such, we are meant to cover the Bankruptcy and the Insolvency Act. And basically, the corporate insolvency earlier on has been dealt under the winding up provisions in the Company Act, Cap 486 of the laws of Kenya. But the insolvency of the natural persons there is formulated an act called the Bankruptcy Act, which is Cap 53 of the laws of Kenya. And specifically, this deals with the natural person. Natural person to mean you and me, all those people who are organic or living. But we know that the law has two persons. We have a natural person and the artificial person. So the bankruptcy that we'll be dealing with in this particular topic or area will be the issues of properties held by either a sole trader or a partner in a partnership. So we'll be addressing the business. So I want to bring everyone on board. So the businesses when they become bankrupt. And because these businesses are owned by natural persons, so we cannot avoid Cap 53. So there is a lot of legal issues, and most of these issues are addressed under the Bankruptcy Act. And it is so wide. And that is why I'm advising that we take solid or valuable time to understand the Bankruptcy and Insolvency Act clause by clause. And the reason that we are doing this, you may end up find yourself in a situation where you need to give a professional advice. Let's say you are the chief accountant or the CEO or a board member of a company. And the reason why you are absorbed is because you are an accounting guru. And when they come for some information on winding up, then you find yourself in a situation that you won't be able to guide. It will be rather unfortunate. So that's where we are. So we'll go as far as the Bankruptcy and the Insolvency Act, to happen, including the appointment of the trustee. We look into the bankruptcy, the process, appointment of the trustee, the adjudication, until the debt is paid or annulled. So we won't touch on the financials or the financial statement. We can start. So a bankrupt is a person against whom an adjudication order has been made by the court, primarily on the grounds of his insolvency. So kindly note, by the court. So it is not any other person who will be there and confirm or call the yourself bankrupt. So any person can be made bankrupt, and whatever makes a person bankrupt legally is stipulated there. Either you have a liquidated debt of 1,000 or more. In other words, you are unable to meet an obligation of 1,000 or more. The Kenyan way of borrowing and not paying, someone will tell you, ebu ni save na 1K, nitakusort. So they are not even indicating when they pay you back, especially when it is done by your close friends or relatives. Chances are they won't pay you back. So if that person is unable to pay and you can confirm through taking this person through the adjudication process, then this person becomes or qualifies to be a bankrupt. 2, the person has committed an act of bankruptcy within the 3 months preceding presentation of the petition. So had this guy gotten yourself into another liquidated debt of 1,000 that they were unable to pay in the last 3 months, they also qualify. And 3, at the time the petition was presented, was domiciled or within a year before, was ordinarily resident in Kenya or carrying on business in Kenya personally or by agent or a member of a firm. In other words, we are saying we cannot control what is beyond our territory. Could be if this guy is not living in Kenya and they are domiciled in China, Hong Kong laws provide for who is a bankrupt, and they could not be in sync with the Kenyan law. That is why we are talking of the person being domiciled in Kenya as at the point of presenting the petition that they are bankrupt. Hope we are together. So the following are the acts of bankruptcy on which a petition may be founded by the court. You said that the court will adjudicate or they'll present an order of saying that this person is bankrupt. 1, where assignment of the property to the trustee, whereby one gives up all his property to be managed by a trustee, provided that the assignment is substantially the whole of the debtor's property, and it is for the benefit of the creditors generally. Now, some people are shrewd, and when they realize that they are about to be declared bankrupt, they are going to amass all their wealth and register them with a trustee. If you recall, we said that a trustee is one of the well-respected institutions, and it is the safest place to store your properties because no one can adulterate them when they are under a trustee, and you believe that the trustee will be acting on your interest. In other words, I'm trying to say, if someone has decided to take all their wealth or properties under a debtor's property for purposes of the creditors whom he or she is owing, then this qualifies. So such an assignment will normally be void unless registered by a deed of agreement, what we call D of A. We'll be coming to D of A. In other words, we are saying, unless this information is recorded in D of A, it will not qualify. So we'll be coming to deed of agreement and its content later on. 2, you have what we call fraudulent conveyance. So if the debtor unfairly transfers his property to one creditor so that the other creditors have no asset to attach their claims on, then this will be declared as an act of bankruptcy. In other words, we are saying you have 10 creditors, let's say. There is one creditor whom you owe, let's say, less, but you've decided all the properties or the assets that you had attached to your debt to transfer them to only one creditor. This is what we are calling fraudulent conveyance. In other words, we are trying to say, if it defeats the purpose of you showing the creditor that you are going to pay back the obligations you owe them, they can present a petition. Are we there? So the transfer of any property to any person who gives one creditor an unfair advantage or tends to defeat or delay the other creditors is an act of fraudulent conveyance. And this can culminate into you being declared bankrupt. 3, fraudulent preference. So where the preference constitute conveyance or transfer of property or a charge thereon, you can connive. You'll approach Mbogwa and tell Mbogwa, kuna jamaa niko na deni zao na wananisumbua sana. And because I'm intending not to pay, si niseme uko na deni yangu alafu hii mali yote ni wekeze na jina yako. You get? That will be fraudulent preference. So you will be taking all your property that is supposed to be attached to the debt to another person for purposes of hiding. Then 4, absenting. So departing or remaining out of Kenya or departing from his dwelling house or otherwise absenting himself or keeping house with the intention of defeating or delaying his creditors. There are some Kenyans, when they owe you, suppose they were living, let's say, in Huruma, they'll just shift and go to the other side of the valley. So jamaa anahama na matresi yake, anaenda kuishi Mathare. So you keep on knocking at their door, but these people are absent. Then they start trying to hide from you. So you'll never trace them. So this is what we are calling absenting. They can even sneak out of this country unknowingly. And when you call them, they are not around. Yeah? Then execution against goods. And this is committed when the bailiff or the one who is given the powers to come and take over the assets or recover, we call them bailiff, has taken possession of goods and either sold them or retained them for 21 days. In other words, we are saying, if you owe me and I come and try to recover my debt, within a period or duration of 21 days, you're supposed to have presented yourself and organize a repayment agreement. If this is not the case, the bailiff will go ahead and try to recover the debt owing by selling that property or the goods they are in possession. If you will not have done so by 21 days and they go ahead and dispose of the goods that they were in possession, then this is an act of bankruptcy. The court can declare you bankrupt. Then petition by debtor. Now a bankruptcy petition by the debtor against himself or a formal declaration of his inability to pay his debt filed with the court operate as an act of bankruptcy. Although the court will have to do the examination, official examination, they will first accept to your statement. Normally say you are innocent until you are proved guilty. So they will take into account your declaration, you've walked to the bank, and you informed the bank, vile maneno inaendelea, I think I'm bankrupt. The bank will record that, yeah, and take it as official position, subject to further investigation. So if they go ahead and carry an investigation and in fact see that you are unable to meet your obligations to a tune of 1,000 shillings and more, they'll go ahead and declare you bankrupt. So you can petition, but the petitioning is not in a way to hoodwink the creditors you owe. The court will go ahead and do the official investigation to confirm that indeed whatever you are declaring is the right position. Then we have what we are calling the non-compliance with bankruptcy notice. Of course, we expect that your creditors will have notified you. Once they go to the court and report that you are unable to meet your obligation, they are supposed to serve you with a notice. Yeah. So a bankruptcy notice may be issued by a judgment creditor in respect of final judgment or order for any amount provided by execution and has not been stayed or already levied. So failure by the debtor to pay the amount of the judgment within 7 days of service of the notice constitute an act of bankruptcy. In other words, if I go ahead and petition in a court of law that this person is bankrupt, I'll be given a notice to serve you. And within 7 days, you're supposed to have made peace with me and declare if you are willing to clear or otherwise. So if you don't clear, then it will go ahead and be declared an act of bankruptcy. But if the debtor applies to have it set aside on the grounds of set-off, if we agree that we are going to organize a payment arrangement, irrespective of how much I will be paying you until I clear you, that will not an act of bankruptcy. But if I'm unable to come up with a payment agreement with the creditor, then I'll be declared, or that will be an act of bankruptcy. And then we have 8 or H, notice of suspension of payments of debts. And this may be in form of or provided that there is a clear intention to suspend the payment. In other words, we are saying that the notice of suspension of the payment of debts, we had come up with a payment agreement. But it shows, or you've proven, let's say you had agreed that you'll be paying my amount in full after a fortnight. The 2 weeks elapses, you haven't cleared me. Now, if the suspended payment, or if it shows that you won't be able to pay, I'll suspend that payment because it's not forthcoming and go back to seek further guidance from the adjudicator. And if we had come up into an agreement and you are unable to honor or the promise to pay, then you are going to suspend the payment and the court will ultimately call that an act of bankruptcy. You are unable to honor what you promised. Now, what should be contained in the petition, or how should you do a petition? One, we've said that if the debtor presents yourself, they are going to get a receiving order, which is made at once without a court hearing and adjudication. So this is made at once to give the court some time to go ahead and carry an investigation. I hope we are together. Then we have the petition by the creditor or the people who are owned. Yeah. So any creditor, including an assignee of a debt, may petition, provided, and we've given these conditions, the debt owed is an accumulating 1,000 shillings, or the debt is certain and is for a liquidated sum. In other words, you've ascertained that the debt is amounting to 1,000, and this can be liquidated. And 3, the petition is based on an act of bankruptcy committed within the previous 3 months. And lastly, the debtor is domiciled in Kenya. You have to meet these conditions. Now, what if I owe you 800 shillings? It's not yet 1,000, so I cannot be declared bankrupt because the law provides for 1,000. And that's why we have this clause down there. We are saying that a creditor whose debt is less than 1,000 may petition jointly with others. So if the aggregate of the debt is 1,000 or more, a secured creditor may only petition in respect of the balance unsecured, unless he agrees to surrender his security. Are we there? There are those people whom keep a security for the debt they are owing. Let's say you went to a Shylock and they said, for us to give you the 1,000 that you are requesting as a loan, you have to give us your flat screen or flat TV to be security. In other words, we are saying if that TV is not amounting to 1,000. In other words, let's say the value of the TV is 800 shillings. So it's not yet 1,000. So the secured amount is only 800. So this creditor should show cause how they are planning to or intending to pay the deficit, which is 200. And this is what we are saying, that the secured amount will remain to be secured. So the balance which is unsecured must be paid, or the debtor should show a way or an arrangement of how to clear the outstanding 200. If this is not, then you go ahead and petition, right? Then presentation and hearing. Now the petition is presented to the court and must be served on the debtor at least 8 days before the hearing. So your petition has been accepted by a court of law. The debtor is supposed to be served with the notice at least 80 days before the day of hearing. So once you receive the petition, you're supposed to make sure that, because you are time bound and people are very keen, especially the lawyers or the people who will be representing the debtor, they'll be keen on the date of the petition. Shall it not meet the requirement, which is 8 days on when it was served? And you've heard even our politicians trying to take advantage of the same. Let's say there is a case of corruption that you've been named and you've been summoned to present yourself, but the notice has not been served. So, and you try as much not to be served with the notice, so you remain indoors. So what the lawyers or the advocates of the plaintiff will do, they'll come and mount the notice at your gate. Now, if I present this notice on your gate, and I can prove that this was done 8 days before, it will be assumed you are served. Are we there? I've come to your gate severally, your gate man is not cooperating, I mount it on your gate. Yeah? So we are saying, if the debtor wishes to oppose, the debtor must do so 3 days before the hearing. So assuming I do it in 8 days, before the 5th day ends, if I intend to go and oppose the petition, I should go on the first 5 days. Because if I go within the duration of 3 days pending hearing, then it will be annulled by the court. Are we there? So the court may dismiss the petition if the creditors fails to do the following: 1, prove the debt; 2, service of the petitioner on the debtor. So you can see. 3, the act of bankruptcy relied on. So this should not be hearsay. Tumesikia mama wa kibanda akisema niko na deni yake ya 300 ya sukuma wiki ama ya viazi na sijamlipa. Then you use that information to confirm or to try and ascertain that I'm bankrupt. Are you getting? So it must be proved beyond any reasonable doubt. And lastly, if satisfied that the debtor can pay his debts or for other sufficient costs. Na kuna watu tu wa kusumbua. They'll wait for you to go and take the painful process. Then, before the 8 days elapses, unapata kwa M-Pesa yako, ting, ting, they pay you back your money. The hearing is tomorrow. So in other words, we are saying, if the debt is cleared before the hearing or before the petition hearing day, then it will be assumed that this person was not bankrupt. They have cleared you before they were declared. Are you getting? Otherwise, it may stay the proceedings of such terms as it thinks fit or make a receiving order against the debtor. So if you are unable to redeem yourself within the duration, then the court will go ahead and give a receiving order. Now, we have the protection of the debtor's property. Of course, when the court goes ahead and declares you bankrupt, they won't just expose you. They have to protect you pending the hearing. So at any time after the presentation of the petition, the court may go ahead and appoint an OR. And the OR will be interim. OR is the official receiver, or someone who will be taking care of your property as the legal process take its course. And the reason why we are doing this, we don't want you to go ahead and we don't want you to rush and take we've talked of the fraudulent conveyance. So to ensure that whatever you already have before we declare you insolvent is safe, the court will go ahead and appoint an OR, the official receiver. And this will be only interim. It is on interim basis. And the OR, or the official receiver, may himself appoint a special manager to administrate your property. The people will have a lot of money and they are just non-committal on meeting their obligations. So the court may also stay any action or other legal process against the debtor. In other words, we are saying, they'll say, stop. Let us take this data easy and confirm whether whatever is being petitioned is true or are we together? And then the official receiver, being the officer of the court, under the supervision of the minister, and we know that our judiciary is an independent institution. So we expect that his duties will be first to investigate the debtor's conduct and report to the court. So the official receiver is not your servant. He's a servant of the court. So he's been placed there to investigate the debtor's conduct. And they are going to report back. Or they'll be acting solemnly as receiver of the debtor's property. And we know that there are requisite, or there is a process that is supposed to be followed. To happen including placing you on the Kenyan Gazette or any other acceptable platform. Could be broadcast or print media. We can go to the newspaper, the dailies, or go to the television or the broadcast. Are we there? So an act, and the reason why we are broadcasting this information is to make sure that no any other creditor or no any other person claims the property that has been tied to this particular creditor who has petitioned. Are we there? So they'll be acting, the OR will be a trustee pending an appointment of a trustee. So he'll be the interim trustee of the creditors. And as soon as the creditors go ahead, and we'll see how the trustee is appointed. If you have, let's say, eight creditors, 3/4 of them must agree that you've appointed this person to represent us. If they don't agree, the decision of the official receiver stays until you come up with a trustee whom you believe will represent you. So during any vacancy, and in these small bankruptcies, the court will go ahead and have an OR. And he may appoint a special manager. The OR can go ahead and say, I want this person to be representing me on this particular matter. So as we indicated, there is an appointee of the minister. So you can imagine how serious or how the resources tied to this person, especially if the debt was small. That's why we are saying that they may go ahead and have a special manager to carry on the debtor's business until a trustee is appointed. That is much accepted. Now we go to the receiving order. The effect of the receiving order or the consequences of making the receiving order are: one, the debtor retains ownership, but they are going to lose possession. In other words, they are going to lose the control of the in other words, if you have a house A, let's say somewhere in Umoja, it is still remain your house. What you cannot do, you don't have any rights of possession in that house, because the house has since been put under the OR, or the OR has gone ahead and appointed a special manager to take care of that property. 2, the official receiver becomes receiver of the debtor's property. You can see how powerful this OR is. 3, no legal proceedings may be brought in respect of provable debts except by leave of the court. So no sooner than we dish out the receiving order to the OR, the matter becomes legal. So no one can go ahead and bring something up on that property. 4, transactions subsequently entered into by the debtor are prima facie invalid. In other words, we are saying from the date that we give you the receiving order, and the OR has been given the powers to administrate that property, any other agreement that you enter into that is attaching or that is talking about that property is invalid. From the word go, prima facie, from the word go. So the receiving order must be advertised in the Kenyan Gazette. Some people are asking who will foot the cost. Of course, we intend that if you are unable to pay, we are going to attach the property that the OR is administering, and whatever the proceeds, some of it will go towards the expenses of doing the gazettement. 2, rescission of the receiving order. So in these situations, the receiving order may be rescinded by the court. 1, if the court has sanctioned a composition or a scheme of arrangement. So the debtor has agreed, let me settle a payment agreement. Let me promise to pay and have an arrangement with this particular creditor. If that is the case, then it will be rescinded. The receiving order will be rescinded. It will not be effected. Or the debts have been paid in full. Mimi nimekulipa pesa yako tumemalizana. Or 3, the court otherwise consider that the order ought not to have been made. If the court goes ahead and realizes that the creditor was just mudslinging you and you are not a bankrupt, the order will be rescinded or it will not take effect. There's something we call statement of affairs. What is it? So within 14 days of the receiving order, but not more than 3 days before the date of the debtor's own petition, the debtor must submit to the official receiver a statement of his affairs verified by affidavit. And you swear an advocate, you swear an affidavit in front of an advocate of High Court or someone who've been allowed by the Constitution to administer an oath. In other words, you'll be going to say that this is the true position. So that when we go to the ground to ascertain, if we get contrary information, then you can prosecute you with the statement of affairs that you went ahead and declared. So in the statement of affairs, you are going to give us all the assets, debts, and liabilities, and you're supposed to do a full disclosure. There are people who are just shrewd. So they'll go ahead and tell you, I have a property somewhere in Utawala that is worth 10 million. What they'll not tell you is that that property is a collateral to ABC Bank. So they gave me a mortgage, and in lieu of the mortgage, I gave them the property. So you see, you've declared you have a property in Utawala, but you didn't say that it is a collateral to the mortgage that you took. Are you getting? So you must take, or you must declare fully. You must give a full disclosure. Kuna kudanganyana. So the names, residences, and occupations of your creditors are supposed to be listed. We want to reach them out and understand whether they have any interest in the property that is to be taken to the official receiver or the special manager. 3, the securities held by them and the dates they were given. So we want you to indicate that such a property is a security to a loan, which I took in 2018. the loan is for 5 years. So the loan will be lapsing in 2023. So no one can go ahead and dispose of that property because it is a collateral to a loan. And lastly, such further or other information as may be prescribed as official or as the official receiver may require. So the official receiver may go ahead and ask you some very uncomfortable questions to happen, including, is your wife aware? No, some men will take debts, but they will not disclose to their best half. So you could be staying in a house, na hiyo house mnakaa as a family iko juu ya deni. What the wife knows is that the man of the house purchased themselves a house for their family. So you can get the scenario. And then it comes one day, the bailiff is outside there with the notice to evacuate you. So you can imagine such embarrassments. So assuming that the order has been accepted, the statement of affairs has been stipulated by the official receiver. We go to step number 4, which is now meeting the creditors. So the petition was made and accepted. We've gone ahead and ascertained that indeed this guy is bankrupt. Then we go ahead and received the statement of affairs of everything that he owns. From there, we are now comfortable. We can go ahead and convene a meeting with the creditors. Hawa jamaa wana kudai. So the OR must convene this meeting within 60 days of the receiving order, unless the court extends the time. So you can see we are time bound. Should be done within 2 months by giving notice to each creditor mentioned in the statement of affairs. Of course, whatever is disclosed in the statement of affairs will now be guiding the official receiver or the special manager to carry ahead the first meeting with the creditors. Are we there? So we'll be doing this, and by 6 days notice in the Gazette. So we are time bound. So we are talking of 60 days after receiving the order, and we are talking of by 6 days notice in the Gazette. So he must send with the notice a summary of the statement of affairs. So when they are serving you with the notice that you are going to meet as the creditors because of debtor A, B, C, who was declared bankrupt. So his own comments thereon is a form of proof and details of any scheme proposed by the debtor. So what the official receiver is trying to say is that the creditors have not yet lost. So I've met with the debtor. The debtor is not yet declared bankrupt because they have these properties. But what these properties are disclosing is their own. If there is any payment or promise to pay agreement that was made by the debtor with the official receiver, the payment proposition is supposed to be attached. What the debtor proposed should also be attached. Of course, the creditors can go ahead and reject it and say this guy has been giving fake promises, which he doesn't honor. So the debtor must be given 3 days notice before the meeting. Now, the purpose of the meeting is to decide whether to accept a scheme of arrangement, if there is any, that is, or to have the debtor adjudged bankrupt. So this meeting is very crucial. It is the determining factor of whether you will be bankrupt or otherwise. Should the creditors accept your payment scheme of arrangement, you will not be declared bankrupt. If they reject, or if you've not provided any scheme of arrangement on how you are going to clear your debt, they'll go ahead and petition for you to be declared bankrupt. 5, public examination. So they've met. The next process will be the court will fix a date of public examination on the application of the official receiver as soon as it is convenient after the time for submission of the debtor statement of affairs. So notice must be given to the debtor and the creditors and advertised again in the Kenya Gazette or a local daily. So the debtor must attend and must answer on oath. Remember, we are in a court of law, so they must swear. So the commissioner of oath will be there. All questions will be properly put for the debtor to go ahead and answer, even if they are incriminating. I said some of them might be very embarrassing. So if the debtor fails to attend or refuses to answer the question, the examination may be adjourned indefinitely, or what we are calling sine die, indefinitely, and the debtor adjourned bankrupt forthwith. So if the debtor is not cooperating and he is the guy who is making the court to meet, then the court may have very little to cover him. They'll go ahead and declare him bankrupt. In other words, we are trying to say it's highly unlikely that someone will accept to be taken all this painful process if they have an ability to pay. Don't you think so? And I'm telling you, the situation that you are putting yourself in is more injurious to you. So if there is anything that you can do it before you are declared insolvent. And you will see consistently how it can injure you. For a duration of 5 years, you cannot even be a director of a company once you've been declared bankrupt. So a bankrupt person is someone who is feared by everyone in the society because this person is so vulnerable and they can do anything to redeem their current position. But once this is affirmed by the court, is a very dire situation. And the court has a mechanism, or the CAP 53 have a process that has to be followed for you again to be declared that you are fit. So you are not bankrupt, you are fit. You are not insolvent, you are fit. So you have the composition and schemes of arrangement. So the debtor may lodge a written proposal with the OR for composition of other arrangement of his affairs within 4 days. So not many people will accept to be declared bankrupt if they understand what it means. So they'll make sure that they submit a payment agreement or an arrangement, and this is what we are calling a scheme of arrangement within 4 days. Yeah. So when they are submitting the statement of affairs, they'll be saying, look, guys, I have this and this. So I'm not yet insolvent, or such further time as the OR may allow. So the procedure is as follows. 1, the OR must summon a meeting of creditors before the conclusion of the public examination. It's very critical. You see, public examination is what will question the OR and will help now the court to make a decision on whether they are bankrupt or otherwise. So the OR must make sure that they summon a creditors meeting before the public examination by the court by sending a copy of the proposal to each of the creditors. So they'll say, look, this guy has agreed that he will be honoring his debts on this and that date. So they'll serve all the creditors with the scheme of arrangement that the debtor has proposed. So the proposal must be approved by a majority. And you can see the majority is 3/4. This is 3/4 in value of all creditors who have proved. So shall it fall below 75%? 3/4 is 75%. So if they were 10 creditors, 7 of them, 8, because it will be 7.5 and you don't have half of a person, must agree. So the stakes are high. So if the proposal is accepted by the creditors, it must be approved by the court. 3 days notice of hearing being given to each creditor. So again, because we are following a court procedure, the termination will still be through the court procedure. So the court cannot approve the proposal until it is heard the official receiver's report on the debtor's conduct and any objections of the creditors. So again, the court cannot make a ruling. The OR was investigating whether whatever you are alluding to is true or not. So there is no any conclusion that can be made pending the hearing of the OR's report. And if there are any objections from the creditors meeting, the court will also listen. So the court should approve the proposal if they are satisfied the statutory requirements have been complied with, and it is in the interest of the creditors and not contrary to the public policy. So it should not puncture the existing constitutional law. Are we there? So the court may refuse to approve in case of the following conditions. Now, the terms are unreasonable or not for the benefit of the creditors generally. Now, if the schemes of arrangement is suiting the debtor and they may end up not honoring the promise to pay, then this could be unreasonable on the part of the creditors. In other words, we are saying that it will be annulled, it will not be accepted. So any of the facts that would entitle a bankrupt or an immediate and conditional discharge from bankruptcy are approved unless provision is made and at least 25 per 100 on all provable and secured debts. In other words, we are saying in the scheme of arrangement, the debtor should show cause and ability to pay at least 25 shillings for every 100 held. So kama niko na deni yako ya 1000, lazima uonyeshane at least. It can be proved you can pay me 250. So this is like a quarter. It should be proved beyond any reasonable doubt. And lastly, provision is not made for the prior payment or preferential debts. In other words, we are saying you should honor what you said here. There should be no debts that have been put or that are preferred to be paid before the particular debt that I had petitioned. Are we there? So if approved by the court, the scheme is binding in respect of all provable debts, except those from which the debtor will not be released on discharge. And we'll be seeing this later in the topic. So the scheme may be annulled on the following grounds. The debtor defaults in payment. So you had provided a scheme of arrangement on how you'll pay, but you don't honor. It will be revoked. 2, it cannot proceed without injustice or undue delay to the creditors. And that's why we said that whatever the proposal that you are presenting should not injure the creditor. You see, the court is trying to ensure that justice is done to the creditor. But if whatever you have proposed will injure the creditor whom you've already injured, and that's why they were petitioning, then it will not stay. Or the court's consent was obtained by fraud. No, especially when we are heading to the elections. There are a lot of scandals that are declared. So Mheshimiwa so and so did not graduate, Mheshimiwa so and so. So there is a lot of maligning. So could be, and we know one of the requirements of Section 6 is that for you to occupy a public office, you must be declared that you are not bankrupt. So someone may have done this fraudulently to lock you out of a public office. So to ensure that this is not the case, the court's consent should be clear of any fraud. If not, it will be annulled. And that's why we are getting the official receiver to do the investigation and confirm, is it true that so and so is bankrupt. I was saying that no one will wait until all this is done if they are willing to pay. So in practice, such proposals are so rare of a debtor who wishes to put forward a scheme. The statement is down there. So they'll normally do so before they are declared bankrupt. So no one will wait until they are declared bankrupt. They'll make sure that they redeem their self before they are taken to the court of law to be declared, or before the confirmation that they are indeed bankrupt. Now, let's come to the judgment, adjudication of debtor. Now, the court may judge the debtor bankrupt on the application of the official receiver or any creditor in the following cases. If the creditor so resolve at their first meeting, or pass no resolution, or do not meet at all. So creditors can decide, we don't want to listen. That guy has been promising, not honoring their promise. So they fail to meet for an agreement or a scheme of arrangement. So in that case, the court will go ahead and adjudicate the matter and confirm that you are indeed bankrupt. So if a composition or scheme is not approved within 14 days, so once we sit and agree that you are going to provide a payment mechanism, should be done within 14 days. So after the conclusion of the public examination, or such further time as the court may allow. So if that is not done within 49, then we'll go ahead and adjudicate the order. Or if the debtor applies to be made bankrupt. So I say there are situations where you will walk yourself in a court of law and go and say, as it is, I want to confirm that I'm unable to meet my obligations, right? So if the debtor applies to be made bankrupt, which is a rare occurrence. So if there is no quorum at the first meeting of the creditors, and if we indicated that 3/4 must agree, in many cases, we might have, especially if they want to cripple the decision of the scheme of arrangement, the creditors may not cooperate. So they will not be there. They will not meet the quorum of the 3/4. So if the debtor has absconded or does not intend to propose a composition or a scheme, there are some debtors who are just difficult. They not provide any payment mechanism. If that is the case, the court will go ahead and adjudicate the matter. So if the public examination is adjourned indefinitely, if that is the case, you said if you are unable to answer the questions that are incriminating, on that particular moment, the court may go ahead and declare you bankrupt. So if the public examination is adjourned indefinitely, the court will go ahead and adjudge you as bankrupt. Or if the debtor fails without reasonable cause to submit his statement of affairs. If the OR is requesting you to go ahead and list what you own to see whether you are indeed bankrupt and you refuse to cooperate, the court will go ahead and adjudge. So you are given some time to clear yourself. And lastly, if composition or scheme is annulled by the court. So you can constitute a payment mechanism, but the court, and of course the court will be working on precedents. If they realize there are elements of fraud, there isn't much or there isn't need of wasting time. They'll go ahead and annul and instead adjudge you as bankrupt. Now, consequences of adjudication or consequences of the judgment. So the consequences of the making of the adjudication orders are as follows. The order must be advertised in the Gazette, at whose cost? The debtor's cost. So the ownership of the debtor's property vests in the trustee in bankruptcy. So after we declare you bankrupt, our special orders will come on the trustee, and he should now go ahead and administer to ensure that the creditors get their hard-earned debt. So the debtor must not obtain credit of 100 shillings or more without informing the creditor that he is an undischarged bankrupt, and credit under 1 shillings can be added together to make this offense. And you have a case there of Hartley. If you are interested, you can refer. In other words, we are saying, so you can see how embarrassing it is. If you have to borrow 100 or above, you have to go ahead and inform all the creditors. Mimi niko na shida ya shilingi 100, I want to borrow. Imagine you want to load credit in your phone. You cannot do so without declaring. And this 100, because you are declared bankrupt, it will be added together to make an offense, because there is no way that you could be bankrupt and you are able to raise 100 shillings. A bankrupt person is a useless person. They have no value. Their scrap value is 0. You can see how serious it is before the court declares you bankrupt. You go ahead. 4, the debtor must not engage in any trade or business under a different name without disclosing the name under which he was adjudicated. Remember, we expect that all the relevant institutions, to happen, including the registrar of companies, the licensing or the permit department with the counties or the municipalities, will be having this information that you are indeed bankrupt. So how could you run a business when you are bankrupt? It's not possible. So the debtor cannot act as a company director or take part in the management of a company, except by leave of the court. So you can imagine where you are a board of director for 5 different companies, where you earn allowances. So it's a painful process. 6, the debtor cannot act as a receiver or manager of the property of a company unless appointed by the court. Of course, there is no way that we can let you have such an honorable position when you don't have anything. And lastly, the debtor cannot be appointed or act as a justice of peace or be elected to hold the office of mayor or member of local authority council, school committee. So you can imagine how, you can see how granular it is. You cannot even head a position in a school committee or a road board. And this disqualification operates for 5 years. So it's not that time that you are declared, for a period of 5 years after discharge, unless you obtain a certificate of misfortune or the bankruptcy is annulled. So you can imagine how painful it is. You cannot sit even in a school committee. The MCA cannot even appoint you usimamie ile mawe huwa the hard course, zile huwa zinamwagwa ama maram kwa hiyo kabarabara ya kuingia kwenye. And for you to redeem yourself from the situation, you got to go ahead and get a certificate of misfortune. So it's not good to be bankrupt. Try as hard to ensure that you are not bankrupt. So annulment of order. In what situations will be the order disqualified? So in the opinion of the court, that the debtor ought not to have been adjudicated bankrupt, if the note realizes that you are not supposed to be declared bankrupt, they'll go ahead and annul the order. They will revoke that you are not bankrupt. Or if all the debts have been paid in full, or a composition or the scheme is accepted by the creditors. So it must be accepted by the creditors first, because these are the people whom you owe. And again, be approved by the court. So as to be, or when the orders are, the debts have been paid in full, voluntary release of a debt is not equivalent to payment. Are we there? So a disputed debt is considered as paid in full if the debtor enters into a bond to pay, if the dispute is settled in favor of the creditor, and a debt due to an untraceable or an unidentifiable creditor by payment of the debt into court. There are situations where the court will do, or the OR will do the examination and realize that this ought not to be listed in the receiving order. So in such a case, the amount that was put there will be considered, or the disputed amount will be considered to be paid in full. So the court may refuse an annulment, although the debt has been paid in full. In other words, we are saying that the official receiver reports that the bankrupt has committed bankruptcy offenses. They will refuse to pull down the case, and it will stay if they can confirm that it is indeed true. So we expect that there will be a lot of disputes here and there. Huyu jamani kuniharibia tu jina, sikuwa nimekata kumulipa. If this is the case, then and the dispute is untraceable, or the debt due is untraceable, the creditor will be put to task. So an annulment must be advertised again in the Kenyan Gazette before it is released. So, and the releases the data from the disabilities of the bankruptcy, but does not invalidate payments or other acts properly made by the official receiver or the trustee. In other words, we are saying that the property of the debtor vests in such person as the code direct until it reverts to the debtor. That is when you will be confirmed that you are not bankrupt, or the bankruptcy will be annulled. So I want to end it there for today. Like I said, it is comprehensive, it is deep. You need to take some time and try to absorb this content for purposes of this particular unit and understanding. So if there are any correspondences, if there are any questions, kindly route them to me via the portal. They'll be responded to adequately. So thank you and have a good day.